The one thing that I have to say right off the front end, and Megan, I do have an idea for swag. For all the speakers, if you could create speaker t-shirts that have a disclaimer on it, so we could just walk around throughout the conference. The views expressed are purely our own. I have a lot of views, so this is specifically for me. And they do not reflect the views or opinions of the Michigan Department of Attorney General, including Attorney General Dana Nessel. So I will proceed. The other thing I wanted to say, I'm going to go quickly off topic. So the conference and events team, C&E, we've repeatedly said how wonderful they are. If you could remind them every day that you are here, that they are awesome, and thank them for all the work that they do. They work really hard to do really great conferences for us. And also, Megan, I'm not gonna let you go off without getting thanked and reminded of how wonderful you are every day as well. Thank you very much for all the work that you do. So one of the things I love about Bootcamp, so if this is your first time at the Law Institute, I realize it's the end of the day. This is the last session that we have before the roundtables, but I just want to put a plug in, if this is your first Law Institute, to please use this as an opportunity for networking, and never feel like you can't call any one of the attendees to ask for some advice or just to share stories or bitch about vendors. Not that there are any bad vendors that you would ever want to bitch about, but like just call and know that you will always have somebody that knows what you're going through. So the first thing we'll go through is we'll provide you with a roadmap. So what we're going to talk about today, successful government contracting, that's kind of a really broad topic, but we're going to go through and provide you with some basics. So we're going to talk about the Model Procurement Code. You've heard about that today versus not. We're going to go through competitive solicitation. You've heard about this today, but we're going to talk a little bit about responsive versus responsible bidders. We're going to talk about good faith and fairness. Keith talked a little bit about this morning. We're going to talk about transparency, also something Keith touched upon. Then we're going to try and apply the basics. And we're going to apply it. We do a lot of IT contracting, as I'm sure everybody does that works in procurement. So we're going to apply the basics to IT contracting, difficulties of IT contracting, licensing and intellectual property, data protection. We're going to talk about applying the basics in negotiation, and you're going to get extra emphasis on some of the slides because some of the slides you've actually seen before this morning, so just pretend you haven't seen them. We're going to talk about that, and we're going to talk about the difference between a business decision and a legal decision and the actual ramifications that might impact you negatively and your states, provide some examples, and give you some takeaways. So that's the path that we're going to follow today. I tend to talk, I'm nervous, as you can probably tell, so I tend to talk pretty quickly when I'm nervous, but please do not hesitate to raise your hand, ask questions, throw things to get my attention. Again, I'm nervous, so I may not see everybody's hand raised, but if you need anything, please stop us, and we're very happy to take your questions. And just know, especially if you're a first-timer, I'm sure somebody else has the same question, so they'll be very thankful that you asked. So again, you've heard about the Model Procurement Code today, developed first in 1979, and it's just a collection of statutory principles. It's a model code. It is not mandatory for every state or even major cities to adopt. Many of them do, though. And so in your materials that come along with this particular presentation, you're going to see a publication from the Megans from last year that talks about the revisions to the Model Procurement Code in light of the digital age, and of course, they're working in this hotel right across the way. So there's a lot of work being done. The last iteration was in the year 2000, and they did update it a little bit with respect to IT, but if it was, of course, 25 years ago. So they're working on updates now to accommodate certain things that have happened. I mean, nothing really has happened in the last 25 years, right? Especially not in technology or anything like that. So if you want more information about the Model Procurement Code, you're going to hear more about it during this conference, but also talk to, well, any of the Megans or anybody at NASPO, and they can help you out. So Again, it's a model code, so it's not mandatory. And there is a 2022 report from NASPO that indicates that 26 of 44 states responding to that survey, so they didn't get everybody to respond. 26 of them have fully or partially adopted the model procurement code. 16 states have not. Michigan is one of those states. We have not adopted the model procurement code, and 2 states didn't know. So again, this comes from a NASPO 2022 survey. Keith McCook, who you will hear a lot about at this conference if this is your first time here, he created a list of states that have fully or partially adopted the model procurement code. That reference is also in your materials for this presentation. So even though different states may have different processes, again, Michigan is not a model procurement code state. We're going to be talking to you mostly about Michigan because we're both from Michigan. But all states and large municipalities also all have some sort of competitive solicitation process. And so one of the things that they look at with respect to competitive solicitation is the bid itself, but they also look at the initial evaluation of that bid tends to take a look at, and this tends to be the threshold question, whether the bidder is responsive or not. So the question becomes, what does that mean? And what does that mean in various different states? The model procurement code defines responsive bidder as a person who has submitted a bid which conforms in all material respects to the invitation for bids. And so this is focused on the bid, but what you'll see is in the state of Michigan, it may focus on the bidder. So we're gonna cite from the Michigan Procurement Policy Manual. So we are not a model procurement code state. Our Chief Procurement Officer, Jared Ambrosier, is vested with statutory discretion. He has very broad discretion to implement the Management and Budget Act, which is the enabling statute for the Department of Technology Management and Budget, and that centralizes procurement purchases for all executive departments and agencies within the state with certain limited exceptions. So there are some that have their own procurement authority, but for the most part, DTMB does centralized purchasing for the entirety of the state for the executive branches of government. They can also create cooperative contracts for local governments, universities, and hospitals to make purchases through those contracts. So much of the CPO's discretion and the processes that govern the way Michigan works is in this Michigan Procurement Policy Manual. And so with respect to responsiveness, what we take a look at is the actual bid itself, not necessarily the bidder. So a responsive proposal is one that is submitted in accordance with the solicitation instructions and meets all mandatory minimum requirements identified in the solicitation. So again, we look at whether the bid meets the requirements versus the model procurement code deals with whether the bidder meets the requirements of the bid. Similar, but a little bit different. One of the things that I realized I totally blanked over at the beginning of the presentation. So as I said, successful government contracting is a very loosely defined concept, but what we're gonna do is we're gonna take these basic concepts. So we're gonna take the basic concepts of the model procurement code if you're not a model procurement code state. And what we're gonna use to define as a successful government contract is one that meets all of these guidelines, the framework requirements of your specific state law, in a manner that demonstrates a meeting of the minds between the parties and creates an effectively written and clearly written contract. And I will say before I turn it over to Dave that my contracts professor in law school defined a successful contract as one in which both parties were miserable. So there tends to be some give and take in all contract negotiation. And with that, I will turn it over to Dave.
All right, thanks, Suzanne. So you'll see responsible bidder. Incidentally, we switched at this point because between the two of them, I'm the responsible one.
Absolutely.
It's not at all true, but now it's on the record. So the MPC provides the definition of a responsible bidder. And as you can see up on the screen, The key words there are capability to perform. So in Michigan, as we've mentioned several times, we're not an MPC state, but we do have a definition that we use from our procurement policy manual. And there the key words are ability to successfully perform. And just to note that NASPO has a publication dedicated to this entire topic, so you can go find a wealth of information as well as other information at the NASPO site. So now, a bidder may submit a fully responsive proposal, but even then, during that evaluation, the state's committee might determine that the bidder is not responsible. And before moving on, both hurdles must be cleared. So you have to be responsible and responsive. So what does being a responsible bidder actually mean? Well, it doesn't mean that the bidders are the ones who are at the party drinking water and will drive us home, right? It means essentially that they have the capability and integrity, and they have to actually be able to perform in good faith. For example, the buyer might check references and discover that while the bidder completed a similar contract for the state, the performance was poor, maybe the work was a little late or below standard, not necessarily enough for you to terminate the contract, but still a factor in their performance. Or the evaluation may reveal that the bidder is undercapitalized or just a shell for subcontractors, and the actual bidder is performing none of the work and the subs are doing all of the work. In those cases, the procurement officer can and should conclude that although the proposal might be responsive, it's probably not responsible. The distinction between the two really sets the stage for understanding good faith under the MPC and under the UCC. When an evaluation team determines responsibility, they're not just checking capability, they are exercising discretion in good faith. In other words, responsibility decisions are real-world tests of good faith. They show whether the state's actions are honest, reasonable, and defensible. So let's take a look at good faith and what that means. So going back to your Contract 101 days, remember that cornerstone principle we all learned: every contract carries an implied duty of good faith and fair dealing, whether those words good faith actually appear anywhere in the contract. As you can see from the quoted UCC section here, there's an implication of good faith. That's exactly what the UCC section quote that you see behind reminds us. Good faith isn't optional. It's built into every agreement. The duty ensures that even when a party has discretion under a contract, they must use it honestly and fairly, not to undermine the deal or take advantage. The UCC doesn't just require good faith, they actually define it. The MPC, on the other hand, requires good faith, but it doesn't define good faith, leaving that open to interpretation. What's especially interesting about the MPC is that it actually extends the good faith obligation beyond the contract itself. It applies to pre-contract activities as well. That means the duty of good faith reaches all the way back to how the solicitations are developed. Bids are evaluated and awards are made, not just how the parties perform after the signature. Now, some states that have adopted all or part of the MPC have filled in the gap by defining good faith in statute or maybe in an administrative rule. But the real challenge isn't so much in defining good faith, it's recognizing what's not good faith, right? That's when things get tricky. Most of us instinctively know something's not right. When a process or a decision just doesn't seem fair or seems tilted, that's the red flag of bad faith being waved. In procurement, questions of good faith versus bad faith arise at every stage, during bidding and evaluations, negotiations, and all through the contract performance. And that's what makes understanding good faith so important for procurement attorneys. You're not just spotting what's proper, you're helping identify and prevent those moments where something crossed the line. And spotting and correcting those moments leads to success in governmental contracting. In Michigan, since we are not an MPC adopter, the duty of good faith that is extended to pre-contract activities comes to us through case law. In Michigan, there is no separate cause of action for acting in bad faith in a contract. It's simply a breach of contract. The implied covenant, however, may be used to aid in that interpretation of a contract or help to otherwise support a claim for that breach. Point being that while the legal route to get there may differ, in most states these concepts exist. Now, we all know good faith when we see it, but bad faith, let's look at a couple of quick examples that may or may not be fictional. Some examples of not good faith. The pre-selected winner. That's a solicitation that goes out to bid, but somehow one vendor's proposal matches the agency's needs a little too perfectly, almost as if they wrote the specs themselves. That might raise a red flag. Were they involved? Good faith means level playing field. Bad faith means an inside track. Another one, the moving target evaluation. It's after proposals come in, the evaluation team decides to tweak the scoring criteria just a little to favor a particular vendor. That's the procurement version of playing a game with my older brother, who always made up some rule in the middle of the game when he was losing. The Let's See Who Notices award. That's when an evaluator spots a major error or omission in a preferred bidder's proposal, but quietly overlooks it. That's not discretion, that's selective enforcement. Good faith applies rules evenly. Bad faith applies them creatively. And the last one I have here, the paperwork gauntlet stall. That's where a vendor that has fallen out of favor now has every invoice scrutinized. Every comma's out of place, gets noticed, even if it has nothing to do with the invoice, every line questioned. Not in a thorough way, but in a retaliatory way, disguised as compliance. Good faith, you try to resolve the issues. Bad faith means you're weaponizing bureaucracy. I'm sure you can all think up your own examples. Hopefully in your practice you don't have too many, but I'm sure if you do, you've come up with better names than I have for them. But as attorneys, that's where we step in to help our clients stay on the right track and make sure we're on the right side of that line. One concept that is always present in determining whether the parties have been acting in good faith and whether there is transparency in our responses that we receive is in the performance of, which is rather transparency. So all of the examples I gave of bad faith that we just talked about, they all share one thing in common. They all thrive in the dark. And that's exactly why transparency is such a safeguard in the public procurement process. Transparency is how we make fairness visible. It's what builds public trust and protects the state and our clients from even the perception of favoritism or impropriety. Transparency on our part is making sure that the bids contain enough information about not only what the contract is required to do, or the contractor rather is required to do, but also the criteria upon which the bids will be evaluated. There shouldn't be any secret internal evaluation metrics. The publication of our contract awards, another indication of transparency. And of course, mechanisms in place to keep records about the processes we use and audits and reviews. Bidder transparency, slightly different. They should be upfront about who they are, including ownership, key personnel, who their subcontractors are, their financial capability, because if they can't meet the performance demands, that should be disclosed. Potential conflicts of interest or relationships with agency staff or other vendors, which was mentioned, a lot of this stuff we're talking about has been mentioned previously, so consider this your summary at the end of the day. But past performance issues, honesty about lessons learned, When bidders are transparent, that can build credibility with the state, right? When they're fully transparent, even if everything's not perfect. But obviously, the bidder's level of transparency isn't quite the same as the obligation of the state to be transparent. The state is working to maintain the trust of its citizens. The state actually owns transparency to the public and to the bidder. The bidder is working to increase sale and profit, and while their future business might be based on that trust, their transparency really is just kind of owed to the state, not the public itself. But an ounce of skepticism might prevent a pound of attorney's fees, especially if their bid is a little bit too good to be true. Keeping in the transparency theme, this is where the open records laws and freedom of information laws become one of the key tools for ensuring governmental decisions are transparent, including our procurement actions, and making sure those can withstand scrutiny. Here's where transparency gets a little tricky. Under Michigan law and in many other states, agencies can receive Freedom of Information Act requests for bid responses before the contract award. Now, that might sound like ultimate transparency. We'll just let everything out in the open. We'll open the vaults and show everyone everything. But in practice, it can be seriously undermining to the integrity of the competitive process, right? If you think about it, if vendors can access their competitors' pricing, the technical specs, the proposals or strategies before the award or before they even place their own bid, the playing field would be compromised. So recognizing this risk, in Michigan, we amended our procurement code to create a FOIA exemption for bid responses that are made prior to the award. That means the bid submissions are protected from disclosure until the award is made, or in some cases, the solicitation is canceled. The logic here is straightforward.
Dave, I think we have a question.
Oh, yeah.
Go ahead.
So what time frame is determined to be awarded? So obviously, once you've had your award, you have a protest period. So do they have the ability to get it once the award is made, even though there might be a protest and there may be a start over of the, if the protest is granted or however it may end up getting canceled and it gets started over, can they, under FOIA, get that information under your statute?
Yeah. So they can get the information. So once the procurement office publishes the bid award recommendation, that's when the FOIA exemption ends.
Yeah,
so
that's the
if there
trigger.
is a FOIA request, that bid information can be turned over. And so there is generally a protest period. It depends, the amount of protest period depends on the amount of the bid. So sometimes it can be longer, sometimes it can be shorter. And then what will happen is we're one of the states that don't have really we don't have a statutory bid protest process. It's through policy and procedure. And so what will happen is the protest will work its way through whatever that process is. Then the state's administrative board will actually meet and approve the contract, knowing that there are bid protests. They try and resolve them before the ad board meets. The ad board approves it, and then the contract is countersigned by the state. So that's the contract effective date. But to your question, once the award is published and made public, that's when the FOIA exemption ends.
Yeah, so we don't wait until after the bid protest period. So in theory, yeah, they can obtain the information and use that to aid in their protest, so to speak.
Yes, thank you. I have that question because we often debate that in our state as well, because we have kind of a similar type of language, and it talks about the timing of the award, but then we have a period where you have a protest.
Yeah.
And the same result, the problem that you're trying to solve can still exist if ultimately the protest is granted and you're starting over.
Right.
So
Yeah,
Yeah.
it's
I was just
tricky.
curious how other states had addressed that issue.
Yeah. The other thing to keep in mind is even though this FOIA exemption may no longer apply once the bid protest, once it's been awarded, the contract award becomes public, there may be other FOIA exemptions that would apply. So if part of the bid, if it was an IT contract and we asked for their security reports, for example, those would be exempt under a different section of FOIA. So there may be some things that won't be turned over, and so what we do is we have bidders submit a public version of the bid and then a version of the bid that redacts the information that they're saying is like security, trade secret. Sometimes they'll try and redact the pricing and say that's trade secret. That is not trade secret in Michigan, so that is not something we will allow them to do, redact.
Yeah, but yeah, definitely once the contract is awarded, all those things that could otherwise be disclosed, that's the trigger, is the award.
Thank you.
Yeah.
Sure.
Any other questions? All right, so back to transparency. And again, before the award, confidentiality preserves fair competition and encourages vendors to propose the best solutions without fear that their competitors will copy or undercut them. After the award, transparency takes priority because the public has a right to know how and why decisions are made. This isn't about hiding information, it's about timing. Too much transparency too soon can actually erode fairness, which is the very thing transparency is supposed to protect. It's a delicate balance. We protect before the award, and we ensure accountability after the award. That's good faith and good governance in action. And a final word on these two topics, good faith and transparency. Good faith is about doing the right thing. Transparency is about being able to show that we did. All right, so let's try and put together the concepts we just talked about by walking through a scenario where the concepts of responsive and responsible bidder might be gray. Here's the setup. So the state issues an RFP for a software solution that will process federal tax information. So we're dealing with sensitive data, high security, and strict federal compliance requirements. And for those of you who might be unfamiliar with FTI, federal tax information, the IRS publishes something called Publication 1075. It includes a laundry list of requirements on states. One of those requirements is that any contract involving software that touches FTI includes something called Exhibit 7. It's Exhibit 7 to the publication. And that has a list of requirements that states must flow down to their contractors. So keep that in the back of your head as we kind of work through this. So the solicitation assumes the software publisher, the company that actually owns the intellectual property, will be the contracting party with the state. That's how in this scenario, the RFP is set up. But when the bids come back, none of them are from the software publishers. Instead, they're from third-party implementers who offer professional services to install, configure the software, and maybe they're pitching to provide the support after the fact. And then to make it even more complicated, you also receive proposals from value-added resellers, or VARs. And they're just entities that simply sell licenses and pass through quotes and handle invoicing for the publisher. So what's the issue here? The main challenge is the state can't contract directly with the entity that actually owns the software, the one that actually controls the license terms and has the authority to grant usage rights. The party who likely will actually have access to the aforementioned sensitive data. Instead, the state is being asked to sign a contract with intermediaries who don't own the product and can't change the license terms because it's not their product. This creates a few key risks: license and IP control. The implementer or the VAR can't legally modify or negotiate the license because it's not theirs. So, if the publisher's terms conflict with state law, say on indemnification or governing law, the implementer has no power to fix any of that. And then you get into accountability and remedies. If something goes wrong, say a security breach, software failure, data loss, the state may have no direct recourse against the software publisher. You're kind of left chasing the intermediaries. Compliance with the federal and state requirements also comes into play because the software, as I mentioned, processes FTI. Remember that bit I told you to hang on to? So the state needs assurances in its contract that the entity controlling the software can actually meet these requirements. It's kind of hard to enforce if the publisher isn't a party to the contract, right? In this scenario, none of the bids that came in from the actual software publisher, the one who owns the IP software. So now let's go through some of these things here, right? All right. Number one, are the implementer of the VAR bidders responsive? Well, responsiveness is all about compliance with the solicitations stated in the requirements. If the RFP clearly says the software publisher must be the contracting party, and the bids come from third-party implementers and VARs who don't actually own the software, those bids may not actually meet a material requirement of the solicitation. That could make them non-responsive. On the other hand, if the RFP language leaves some flexibility, then those bids might be responsive. I'd actually like to hear from the group if your state would consider third-party kind of intermediary bids responsive in these type of scenarios. I don't know if any of you have encountered those when you're bidding for software. Yeah, what do you guys do with those?
So this was like the perfect hypo, because this may or may not be applicable to my client currently. So hypothetically, if we did an RFP for a solution, right, so for the software itself, unless it's, we typically separate the implementator services, which are, separate from the software services. So the implementators would not be responsive to a solution-oriented RFP. Now, the second part of the question, I'm currently debating and arguing, right? Because theoretically, if they can provide the solution as a reseller, are they, and we didn't have anyone else that was, completely responsive, is it close enough? It kind of is going to depend on what those value-added services are and whether or not they can pass through and execute EULAs, with the state's terms and conditions. So that was number one.
Yeah.
Hypothetically, thank you for that response.
Yeah. No, it's a common issue, and one driven by the current market where, a lot of the software is being offered by third parties, right? Not necessarily the people who own the IP. In general, in Michigan, the answer is, maybe, probably,
Yeah.
depending on how
Depends on the
strictly you draft the RFP. But yeah, definitely.
Although I will just say that is a really good hypothetical response with respect to splitting the software bid from the implementation bid. So that is a really good idea and something we're going to discuss a little more.
Yeah, for sure. So that covers responsive. Are they responsible? So responsibility goes beyond just the paperwork, right? So even if they're responsive, the eval team still might ask things like, does the bidder have legal authority to actually deliver the software? Do they have the ability to perform? Were they transparent about their relationship with the software publisher? Did they actually indicate in their bid that they are in fact a third party, that it's not even their software? Was that apparent at the time of the bid? So if the implementer or VAR can actually control the license terms, or they lack financial stability, or they don't have the necessary security or the ability to flow down those terms to the actual publisher, that's again another potential red flag, right? So one thing to keep in mind here, which will be important in a little bit, is the determination whether a bidder is responsive and responsible, at least in Michigan. That's a business decision. The decision to award a contract is also a business decision. All right, so let's go through some of these options here. So option one, so these are all options in response to this scenario. We could require the implementer of the VAR rather than the software publisher. So we require the implementer of the VAR to actually sublicense the software to the state so that we are getting the actual license from the implementer or the VAR. On paper, this might seem like a convenient solution. It simplifies procurement. You deal with the implementer directly, and they happen to just bundle the software license with their services. But this approach comes with some real drawbacks and risks that are important to understand. First, it means the state's right to use the software depends entirely on its relationship with the implementer or that VAR. If the implementer goes out of business, loses its reseller authorization, or the relationship between the implementer or the publisher breaks down, the state could suddenly find itself without a valid license, and it could be critical software. In other words, the state is stuck in a relationship with the middleman for continued use of this product. Second, the implementer or VAR may not have the authority to actually negotiate or modify any of the license terms, even if they somehow have the right to sublicense it to you. So it lacks a lot of flexibility. Finally, from a transparency and competitive standpoint, this setup can obscure who really controls the product. The implementer may appear to be the vendor, but in reality, still the publisher holds the key. So while option one can seem administratively easy, it often leaves the state with restricted rights, limited leverage, and long-term risk, especially in critical systems. All right, a second option is to have the state sign a separate license agreement with the software publisher. And now we just pay the license through the implementer of VAR. But in this setup, the state, they at least have a direct relationship with the software publisher, right? But it also has drawbacks. First, the license terms often favor the publisher. You're typically going to just get the publisher's license agreement, the vendor paper. Second, publishers can change those license terms oftentimes unilaterally, depending on what those terms are. I don't know how many of you have seen those terms, but they often reserve the right to change them. Third, in this scenario, you're just paying a markup for someone who's just kind of cashing the checks, not providing you a lot. So, you're going to get a markup on that. So while this option gives the state more protection than option one, it still means a loss of control, higher cost, and ongoing complexity in managing those licenses. And then there's this third option, which was kind of mentioned before, which is, hey, you may be thinking of just splitting them both into two totally separate contracts. One for the purchase of the software and another one for the implementation services, that you're contracting with the implementer. But the problem is, you didn't bid it that way, right? So again, in our scenario, we already put out a bid, and because the publisher didn't submit a bid, wasn't listed as a subcontractor, the state can't just bring them in after the fact. Mm-hmm. So while maybe ideal from a legal structure standpoint, it may be off limits procedurally if the solicitation did not anticipate that structure. Now, if you bid it that way, great. If you bid them as two separate bids or indicated that that was an option, but that's not usually how those kind of roll out. But as much as all that may cause an issue, another and potentially bigger issue is data protection and security. So another critical factor in determining whether a bidder can meet the requirements of an RFP is data security, right? That's kind of at the forefront of most people's minds these days. In this scenario, remember that the software solution was for a solution that would be processing FTI. That triggers all those requirements I mentioned in Exhibit 7. Here's the real challenge. If the implementer or VAR is the contracting party, but the software publisher actually controls or hosts the system, how do you ensure those IRS requirements flow down to the entity that's handling the data?
So one quick thing I just want to jump in and mention is that there is required to be privity of contract in publication 1075. By the way, if you hear pub 1075, that could be this publication. It could be a pub where the public fisc plays. I think that's another good idea.
Opening night.
But the important thing to keep in mind is that it does require privity of contract with whoever is holding or processing that data. That's number one. And the other thing so it's very similar in that respect to like a BAA. So flow down terms require privity of contract and actually needs to follow the chain of contracting. So these are all things to keep in mind. This applies to any federal flow down requirements as well. They all tend to require that privity of contract issue.
Yeah. So I'll skip my next paragraph.
Sorry.
No, you're great. So at any rate, the privity of contract is kind of a key concept. All right, so what we typically try to do in these scenarios when we can is we try to make the software publisher an actual subcontractor. Not always successful in that because you get a lot of resellers and implementers who don't want to take on that liability. Because in that type of scenario, they're the ones responsible for the data loss, and then they would have to go seek redress from the publisher. So again, it's not a perfect fix, but it is at least a way to demonstrate compliance. But all of this circles back to that threshold question of responsiveness and responsibility. So if a bidder can't structure their contract in a way to ensure that the FTI protections reach every party who has access to the data, they may not actually be able to meet the RFP requirements that were bid. All right, now back to Ms. Hassan.
Thank you. So I need to, before I get started, I need to apologize to the IT team. They've been very carefully monitoring the following of the notes and scrolling down. I don't follow notes, so you guys are off the hook for me. Like, don't worry about it. You don't have to follow anything that I'm talking about because I really have no idea what I'm talking about most of the time anyway. So to apply the basics, and we talked a bit about this when Kelly did her presentation earlier today. So negotiation and business decisions. Now, we need to determine what a business decision is, and so we'll go through many things here. But the important thing, as Kelly mentioned, is you need to know who the client is, and they need to know if they are responsible for making those business decisions. If you have nobody that is both responsible for and willing to make those business decisions, you could be negotiating the best contract of your life. And if nobody makes a decision, there's nothing you can do about it, right? Because it's not your business decision. So what is a business decision? Things like what the state is trying to buy, is it clear? One of the things we've taken to doing is reading through a statement of work to make sure we understand what we're actually buying. If we're not, we're lawyers, we're not IT professionals, so we don't necessarily know what the requirements are, but it still needs to be clear. So we look at it like we're a judge that's super busy, maybe a judge's clerk that's super busy and needs to understand the very basics of a contract. And if it's not clear in that very basic, plain English kind of way, it's probably not going to work out great. Determining the business requirements, what needs are the states trying to meet. We talked about the importance of the software solution or system. So in Michigan, we have different classifications. It's changed recently. The most important software systems used to be called red card applications. If they go down, state government just doesn't function the way it's supposed to. Now they're called tier 1. Some states have this classified in law, others have it in policy, and ours is in policy. And then we talked about how much data we're willing to lose. Again, this depends on the importance of the system. And then what is a legal decision? So does your client have the authority to make the purchase? So one of the interesting things, there are many interesting things about what we do as state procurement lawyers. One of the interesting things that I learned is that our main client, the Department of Technology Management and Budget, has procurement authority only. So it can buy things for the state of Michigan and set up cooperative purchasing, what we call my deal contracts for local governments and things like that. But we don't have the authority, DTMB doesn't have the authority to issue or manage grant programs. The legislature did not vest grant acceptance, issuance, or administration in DTMB. Now, if the legislature decides to do that, we'll have that authority, but until that time, if DTMB gets the request to administer a grant, we have to say, sorry guys, that is not in our enabling statute. We don't have that authority. So in that respect, that is a legal decision. You may have to do some research and figure it out, but that is a legal decision. Is the subject matter of the contract legally permissible? have all illegal terms been removed from the contract? And we've had this discussion quite a bit today. There are a couple of different ways you can address this issue. And then negotiation, during negotiation, we need to make some other decisions, legal decisions. Are all terms that may be legally required in the contract? So I don't know about your legislatures, but our legislature has the tendency to come up with amazing ideas that they don't consult with anybody about, really, and say that we have to add required contractual language to all contracts, regardless of whether that language would actually logically apply to the type of contract. It has to be put in all the templates. And this is not something always that your client is going to know about. So we're in the AG's office, and sometimes we hear about these absolutely brilliant ideas from the legislature, and we have to implement them and put them in our templates really quickly. Is the order of precedence correct? This was addressed in the morning. Is your client agreeing to give the contractor total control? Again, we can't do this in Michigan. We have a constitutional requirement that the AG is the only entity that can represent state government in litigation. So if they say we don't have a say in any type of settlement or any type of litigation, especially if we're seeking indemnification, we tell them simply to dismiss, work to make sure the state of Michigan and all of its agencies are dismissed as defendants, and then they don't have to worry about it. Other legal decisions may vary based on statutory requirements and the purchase. So another thing to think about, which is kind of a hybrid decision, one of the things we came across during COVID, so a lot of contracts in their standard terms will include force majeure language, and they'll include that force majeure language even in IT contracts. But one of the things to consider, and this may be one where you will advise the client on what may happen, but if, say, you have a system that manages all of the emergency resources throughout the state of Michigan, we're a border state with Canada, so maybe we're going to work with Canada on some resources, and Ohio and Indiana because they border us. Do you want to actually have a force majeure clause in that IT solution? Maybe you want to make the vendor ask for it, but maybe it's not included in the bid. So you might want to advise legally what the ramifications will be if you say there's a force majeure event, and even though you need that to deal with emergencies, an emergency causes the solution to go down, that's not really going to help you in the emergency situation, right? So these are kind of things that you would advise on from a legal perspective, and then the business may have to make this decision. And then some hybrid decisions again. Does it open the state up to potential civil liability? Jeopardize the public fisc? And does the contract jeopardize the public's data? And we talked about these things. So again, and to reiterate, your clients may want to make decisions that may hurt you personally as a taxpayer, right? And it may annoy the heck out of you, but if it's not illegal, that's not a legal decision, right? So sometimes you just have to live with it and collect dumpster fire little ornament things to put on your desk or behind your desk. So this is actually a great case. I didn't include a copy of the case in your materials, but I do really recommend it, especially if you're in-house counsel. So we're AG counsel. It's pretty clear that we're lawyers and they're the client agency. But especially for people that work in-house, it's really important to make the distinction and to not overstep the line between making a business decision when you're acting as a lawyer. So in this particular circumstance, I'm not going to go too deep into the fact pattern because we're getting a little close on time. But what I will say is a lawyer was hired to represent, or a law firm was hired to represent an insurance company that provides legal liability malpractice insurance, right? Which seems like a really bad insurance company to work for because you know you're going to get sued a lot. But anyway, so the law firm that was hired to represent this malpractice insurer wrote a memo and recommended that they deny the claim. And what the court said, and this is a Sixth Circuit case, but what the court actually said was, the insurance company's job is the business of insurance. The lawyers came in, and they may have performed work product because they were anticipating litigation, because this is a legal malpractice and everything they would anticipate litigation for. So they brought them in, they did work product. There may have been some attorney-client privilege conversations related to writing this memo, but because they actually made the recommendation with respect to denying the claim, that was actually performing the business of insurance. And so in that respect, the court said, work product does not apply to this memo. Attorney-client privilege doesn't apply for a different statutory reason in Ohio. And so that memo was actually required to be turned over. I think it was to the court for an in-camera review, and then it was eventually turned over to the law firm that was suing the insurer. So it can have very significant ramifications if you make a recommendation related to a business decision. And instead, what you can do is you can lay out what the legal ramifications would be for or against making that decision, but the decision is on the client. So just again, super important distinction. You don't want to run afoul of issues that can jeopardize work product privilege, attorney-client privilege. And I highly recommend, even though this is a Sixth Circuit case, take a look at it for the fact pattern and just some background. And then if you want to shepherdize it to see if it'll help you in doing your research, highly recommend it. So we're going to go through some really quick scenarios to determine what is a business decision versus what is a legal decision, and then we're going to get into some summary of 5 key takeaways.
Yeah, great. And just a really quick old lawyer piece of advice. Give your business advice on the phone and your legal advice in writing. I guess people probably don't use whatever they do with cell phones these days. All right, so here's our scenario. We have a red line edit. You're looking at a contract in which the state is purchasing, I don't know, some commodity, and the contractor struck final acceptance, suggesting to replace it with the word delivery. Is this choice to accept the edit a business decision or a legal one? Any thoughts? Business, legal, silence.
I saw a kind of hand back there. Does anybody want to jump in? No? Okay.
All right, I'll end the suspense. It's a
Okay.
business decision, right?
Okay.
So what is your role here? So first you have to understand the significance of the change. So regardless of what the edit is, whether it's this example or something else, even if it's a business decision, you still need to be able to explain the risks associated with accepting it. So in this case, they're completely shifting when title transfers, right? So in the original language, it doesn't transfer until you've accepted it. So there's some kind of review that happens. With their edit, title transfers the minute the product hits wherever the delivery location is. So your job is to make sure your client understands the impact of these proposed edits. So keep in mind that many and most business decisions carry some legal risk. But again, choosing to accept it's a business decision. All right, second scenario. Here we have a scenario where we have a unilateral limitation of liability on the state, no limitation of liability on the contractor whatsoever, but rather than trying to make this mutual, they just struck it, so nobody has a limitation. Both parties have unlimited liability. So this may look like a straight legal decision, right? But if uncapped contractual liability is not otherwise legally prohibited in your state, then really your role would be to advise the client of all the risks associated with accepting this uncapped liability. In the end, it's a business decision. And another old lawyer mantra, you advise, they decide. All right, last scenario here. Contractors adding a whole clause. So this clause deals with keeping everything they submitted to you confidential, including the contract terms themselves, so pricing, those type of things. So is accepting this language into your contract a legal or business decision? Well, this would depend on your state's FOIA laws. In Michigan, pricing is not confidential. except in some rare
Very rare,
circumstances that we don't really need to get into, but I don't want to throw out a blanket statement that's not wholly correct. And depending on what they claim to be a trade secret, just because they call it a trade secret doesn't mean that it actually is, because we've had vendors attempt to say their pricing is a trade secret and try to backdoor that in.
We've had federal agencies tell us that
Yes.
their pricing is trade secret, and that's a whole other fun conversation that I'm not going to get into because this is being recorded for posterity.
Yes, we won't go into the specifics.
We will not
the
go into the
specifics of that one, but
specifics of that one.
it was an interesting
Just know
argument.
it happened, and I'll talk to you at the reception.
But at any rate, this one, again, because we like to end on gray areas, is a bit of a combo. So this may be a legal decision in certain pieces and a decision that you have to consult with your business in others.
That is a hardcore, red, angry
Oh.
timer telling it, that's hardcore, you guys. Okay, I'm gonna speed it up. It's
We
fine.
got 15
Don't
seconds
start the
left.
orchestra. So we're just gonna go through the 5 top takeaways. So again, the definition of success is different for every state, contract, situation, but generally it means that we've got the basics right. It's gonna comply with the law, and we create, again, a well-written contract that accurately reflects the parties' meeting of the minds, and to quote my professor, and everybody is a little bit miserable. State procurement models dictate the pathway your state may legally take to get to success. Responsive versus responsible determinations can have a big impact on your contract negotiation strategy and can otherwise make the lawyer's life miserable. I did not add that on the slide. And then Dave, if you...
Yeah, the last two really quick, those R&R decisions, the responsive, responsible, they can be really tricky, especially in the IT field when you have third-party bidders. And then lastly, the difference between business decisions and legal decisions are very nuanced and very fact-dependent. But remember that only one of them is privileged. So
We are 8 seconds over, but thank you
close.
all for your attention to this presentation. We really appreciate it. I highly recommend, again, if you don't want to reach out to us, I totally understand, I'm a little weird, but do reach out to other people at NASPO that you meet. All of us are wonderful. We're all friends here, most of us. And so please do reach out if you have any questions. Thank you.